Mr. Chief Justice, and may it please the Court. The Tenth Circuit imposed two requirements on religious accommodation claims that eliminated liability for respondents' refusal to accommodate Ms. Eloff here. First, that the applicant herself verbally requests the accommodation, and second, that the employer know, rather than just correctly understand, the need for an accommodation. Neither requirement makes sense.
What is the difference between knowing and correctly understanding?
Your Honor, the testimony, it's a fair question. The Tenth Circuit perceived a difference. What the testimony was that Ms. Cook assumed that that Ms. Eloff needed to wear the headscarf because she was religious, that she figured that the headscarf signified that it was a religious headscarf, and that she figured it was a religious headscarf. What the Tenth Circuit said was that was insufficient. What was needed was actual knowledge. Our position is that when you figure, when you assume, when it signifies to you that a religious accommodation is needed, that is sufficient notice for an employer to be on notice.
I think there's substantial force to your argument that the employee doesn't have to mention this first. But why do we import the term understand instead of know? In a treatment case, the whole idea is that the prohibited action was taken because of religion. Well, you knew. Why are you making it so confusing?
Your Honor, with respect, it's our position. It's the Tenth Circuit that's made it confusing. What the Tenth Circuit has done is said when you know, when you are.
Your statement that you opened with is that he must understand. You stay away from the word know. Justice Scalia asked you why you did that, and I can't understand your answer.
So the answer, Your Honor, is we think that there is sufficient knowledge, notice, when somebody understands that, when somebody assumes that a practice is religious and then acts upon it, that is sufficient.
You're confusing me enormously.
Okay.
Would you tell me what it is you want? I mean, you just say he understands. That doesn't do anything for me. What? He understands, knows, believes, suspects. What other verbs do you need?
So, Your Honor, the test that the courts of appeals have adopted for more than 2 decades, which is the test that we ask this court to adopt, is that the employer needs sufficient information from any source about the employee, about the applicant's religious needs to permit the employer to understand the existence of a contract. That's the test that the courts of appeals have been applying.
I don't care what they've used. That doesn't make any sense to me.
But, Your Honor, the reason why I think it makes sense in this case is because if it's sufficient knowledge for you to actually act upon it. Remember, if the critical point here for us is if the employer had not assumed that this was religious, had not believed it, they would have hired her. The default rule for I'm not sure is hire.
And let's say you have someone of Middle Eastern appearance who shows up for the interview with a beard. And the employer, like Abercrombie and Fitch, they don't like beards. They don't want their models, as they call them, having beards. But he doesn't know if the beard is there for a religious reason or not. So you think it's better for him to sit there and start asking this applicant questions he would not ask anyone else about religion? Why are you wearing a beard? Is there a religious reason for that? It seems that your solution causes more problems.
So, Your Honor, I have 2 responses that I'd like to say. First, I don't think it's right that the solution causes more problems, because I don't think that what Congress would have preferred is that the person not get hired than that the dialogue be begun. If those are the 2 options, I think it's clear Congress wanted an accommodation of the religious practice. But I also think that Your Honor's hypothetical points out quite nicely that it's a somewhat artificial situation here. What the employer is saying is, I don't want a beard when the person is on the floor. But that's not a reason not to hire someone who walks in the door with a beard. The New York Yankees, for example, have for decades had a no facial hair policy, but they don't not pursue free agents that wear beards. They assume that those free agents can shave once they get to the Yankees.
Is it reasonable for an employer to say, look, I don't want to buy into some problem with a guy who has a beard. I'm going to say, can you shave it? He's going to say no, or he's only going to shave twice a week. I mean, isn't he reasonably say, let's say, I don't care if it's a religious reason or not. The guy shows up with a beard. I'm not going to hire him.
So, Your Honor, that's the hard question I think Justice Kagan was asking, and I do think that's a trickier question. If your policy is not, I have a work rule that I'm concerned you won't be able to comply with in the future, then I think, for all the reasons I've said thus far, it's all set. If the question is, when someone comes to my office with a beard and I just think it's unkempt, I don't like it, I'm not going to hire them regardless of whether they could comply. I think that's the situation that presents this. Is it 1/3? Is it 2/3? I think that's a hard question. It's not the one presented here, and quite candidly, it's not the kinds of cases that we actually see. They much more are the work rule.
You could avoid those hard questions, whether it's understand, believe, suspect, by adopting the rule that the Court of Appeals adopted here. And that is, if you want to sue me for denying you a job for a religious reason, the burden is on you to say, I'm wearing the headscarf for a religious reason, or I'm wearing the beard for a religious reason. That avoids all problems. Once you notify the employer that it's for a religious reason, you got him.